just to sort of introduce the two topics, I think we have two very interesting topics today. One is on non-discrimination. Again, one of the lesser articles in the treaty, some may say, but again, has a lot of relevance. The non-discrimination article is to sort of have things in check to ensure that a foreign person who's getting access to the treaty benefit is not treated more adversely than a Indian resident. And for that, we are going to have Mr. Vohra take the session on that. The second part of the session, we are going to be dealing with the principal purpose test. We've had an earlier session where we've discussed with some of the aspects around MLI and the PPT. We're going to have a more in-depth discussion around the PPT again, for which Mr. Butani will be there. So without too much of ado, I'm going to give the session to Mr. Vohra. We don't need to introduce him. I think everyone who's in the tax field, he's one of the peers in the profession and one of the seniors out there. So Mr. Vohra, with that, over to you for your session on non-discrimination.
Good morning, good afternoon, and good evening, friends across different time zones. I hope you are all safe and healthy in the confines of your homes. I am thankful to Nishith Bhai and the NDA team and Dhruv in particular for putting this together and giving me this opportunity to be part of this memorable journey for knowledge dissemination in these difficult times. And it's a befitting occasion when we celebrate Nishith Bhai's 70th birthday. Friends, COVID-19 is a time of scarcity. Almost everything is scarce, including the time. So my time is rationed, and I have 20 minutes to present, as Rajesh said, this rather complex subject and an article which is not very often used in actual practice. As the name suggests, Article 24 is the non-discrimination article, but this is quite unlike COVID-19, which does not discriminate between nationals, between residents, and between enterprises of different countries. So with that brief introduction, let me get straight into the subject. Article 24 is intended to ensure that nationals or residents or enterprises of the two contracting states who are parties to or signatories to a tax treaty are not differentially treated so long as they are similarly placed and in the same conditions or in the same circumstances. So wherever there is discrimination permitted, that must be based on reasonable or intelligible differentia or criteria which distinguishes persons or things that are grouped together or others that are left out, and the differentia must have a rational relation to the object sought to be achieved by the legislation in question. So this is a brief outline of Article 24, and this article, as the name suggests, is on non-discrimination. So what do you mean by discrimination? And this is the dictionary meaning that I have put up on the slide, which I need not go into. So different treatment, as the slide suggests, constitutes no discrimination when it is objectively justified, or at least in economic matters not arbitrary. So it must be based on intelligible criteria which can stand the test of judicial scrutiny. Now, Article 24 of the OECD or the UN Model Convention contains non-discrimination provisions, and I'll take you through the various paragraphs of this article. We have paragraph 1, which talks of nationality non-discrimination. We have paragraph 2, non-discrimination for stateless persons having nationality. Paragraph 3 deals with permanent establishment non-discrimination. Article 24.4 talks of deduction non-discrimination. Article 24.5, ownership non-discrimination. And the last paragraph, in paragraph 6, is a general provision dealing with the taxes that are covered in this article. So Article 24.1 is the main article dealing with nationals. And it is important that this article must be gone into in some depth, because there are several issues and several nuances that arise from a reading of paragraph 1 of Article 24. It reads, and I quote, nationals of a contracting state shall not be subjected in the other contracting state to any taxation or any requirement connected therewith, which is other or more burdensome than the taxation and connected requirement to which nationals of that other state in the same circumstances, in particular with respect to residents, are or may be subjected. I'll just stop here for a moment. So basically, if we break this up, we first need to understand what is the meaning of nationals of a contracting state. Then we need to look at the requirement that they are not subjected in the other contracting state to any taxation or any requirement connected therewith. The next is which is other or more burdensome than what nationals of that other state would be subjected to. Then in particular with respect to residents. So these are the various limbs of this paragraph that need to be satisfied in order that one can invoke the benefit of Article 24(1). And the last sentence in this paragraph, this provision shall, notwithstanding provisions of Article 1, also apply to persons who are not residents of one or both of the contracting states. So the first question that arises is, does nationals refer only to natural persons, or does it include legal persons or artificial judicial entities? So the term national is defined in Article 3(1)(f) of the Model Convention as any individual possessing the nationality, any legal person, partnership or association deriving its status as such from the laws in force in a contracting state. So if we look at this definition, we have now views around it, that what will be defined as a national and whether a corporate entity can be treated as a national of the other contracting state. So unless there be a restriction on excluding a legal entity, the legal entity incorporated in another contracting state would also be treated as a national. And in my article, which is part of the Amicorium that has been brought out, this has been dealt in some detail of where in certain situations corporate entities are excluded from the ambit of the term national and therefore not entitled to the benefit of Article 24(1). Of course, there will be in other paragraph that we'll come to. So I am not, for conserving time, not going into that at the moment, but this is part of my article which is published. So the first was national, then that requirement of they should not be subjected to taxation or other requirement. And this taxation or other requirement will include not only the tax that is actually called upon to be paid in the other country, but also requirements relating to filing of returns, assessment, and so on. That cannot be more onerous, more burdensome as compared to nationals of the resident state. Now, the next important point is in same circumstances. Now, the treaty language differs in different jurisdictions, in different treaties that India has signed. In some cases, it says same circumstances. In some others, it refers to substantially similar circumstances. But this has generally been interpreted to mean that same circumstances would mean substantially similar circumstances. So there, again, this is a matter of interpretation that has been, gone into by courts, by the authority for advanced ruling in different decisions that have been rendered till date. So if basically now the question of taxation, whether the rate of tax that may differ for a resident and a non-resident, can it be said to be a case of discrimination? That our law also clarifies, the explanation in section 90 also makes it clear that merely because the non-resident is subjected to a higher rate of tax cannot be a case of discrimination. So that is not a case where you can invoke Article 24(1) and say that the non-resident should also be subjected to the same rate of tax as in the case of a resident. So again, then we saw same or similar circumstances. The courts have held that if the circumstances differ, then a discrimination is permitted. So these are some of the cases that I have mentioned on this slide, where a different treatment advocated to non-residents was accepted by the court and not a case of discrimination. So as an example, now the protocol to the India-Turkey tax treaty says that taxpayers, that individual legal persons, partnership and associations, placed from the point of view of the application of ordinary taxation laws and regulations in substantially similar circumstances, both in law and in fact. Amongst other things, this means that a national of one of the states, resident of a third state, and doing business in the other state will be subjected to the same taxation or requirements connected therewith in that other state, to which a national of that other state, resident in a third state, and doing business in that third state is or may be subjected. So the protocol to the treaty makes the position clearer. In fact, it leaves no room for any ambiguity, no room for any interpretation. So in this context, where the treaty makes it clear, and this can be used as one of the illustrative aids to interpretation, that in such kind of a situation, the benefit of Article 24(1) should be accorded. So this is in the context of paragraph 24(1), whether there is non-discrimination that is practiced on the Indian side is a matter that needs to be considered having regard to the express parameters laid down in Article 24(1). And as I spelled out, these are the 4-5 parameters that need to be satisfied in order that you can invoke Article 24(1) and plead that on the basis of the non-discrimination article, the non-resident should not be discriminated vis-a-vis a resident. There is a question that is here. Should I take it here, Dhruv, or take it later?
So we can take it at the end. I think that's fine.
All right. So we will do that in the end. So this was so far as paragraph 1 of Article 24 is concerned. And I just come back to the last part of paragraph 1, which talked of this provision shall, notwithstanding provisions of Article 1, also apply to persons who are not residents of one or both of the contracting states. So normally the treaty benefit is reserved for a person who are resident of one of the contracting states. Only they can claim the benefit of the tax treaty. But this provision also extends to nationals of one of the contracting states who may not be resident for tax purposes of one or both of the contracting states. So if the nationals of one of the treaty partners enjoys income in one of the contracting states but is not resident in either of the states, he can claim that he should not be subjected to taxation more burdensome or more onerous than the nationals or residents of the particular residents of the source state. So this is so far as Article 24(1), the last limb, is concerned. And it is important that this particular sentence, the last sentence, is not there in many tax treaties that India has signed with several countries. We will, as we come along, we will discuss what is the implication of this particular sentence be conspicuous by its absence in Article 24(1). So I'll move on to paragraph 2. Paragraph 2 talks of stateless persons, and it reads, stateless persons who are residents of a contracting state shall not be subject in either contracting state to any taxation or any requirement connected therewith, which is other or more burdensome than the taxation and connected requirements to which nationals of the state concerned in the same circumstances, in particular with respect to residents, are or may be subjected. So stateless persons who may not be nationals of one of the contracting states but are resident of a contracting state, they shall not be subjected to discriminatory tax treatment in the country of source. So this is intended to provide benefit to stateless persons who is a resident of either of the countries. So if he is not a resident of either of the contracting partners, he would not be entitled to the benefit of Article 24, paragraph 2. Paragraph 3 of Article 24 talks of fee non-discrimination, and it reads, the taxation on a permanent establishment which an enterprise of a contracting state has in the other contracting state shall not be less favorably levied in that other state than the taxation levied on enterprises of that other state carrying on the same activities. This provision shall not be construed as obliging a contracting state to grant to residents of the other contracting state any personal allowances, reliefs, and reductions for taxation purposes on account of civil status or family responsibilities which it grants to its own residents. So when a permanent establishment of a foreign enterprise is subjected to tax in the country of source, the question that arises is, how should this permanent establishment be taxed? Now, normally, as we know, that a permanent establishment is treated as non-resident for Indian tax purposes, is subjected to a higher rate of tax than applicable on domestic companies or domestic enterprises. So this is just to illustrate this particular provision, where you see that the UK parent has an Indian PE and the Indian PE is earning income in India subjected to tax in India. So therefore the question is, the taxation on the Indian PE should not be less favorably levied than taxation levied on enterprises in the state of source, which is India for this example. So there have been many issues that have been raised with respect to the taxability of a permanent establishment, and there are many judicial precedents on this aspect of the matter. So the first is, it must be engaged in the same activities. Now this is important in order to ensure that the PE is not discriminated vis-a-vis a domestic company, and the expression same activities, although not defined in the convention, has been explained in the OECD model commentary by way of an illustration. And I just quote, similarly, regulated and unregulated activities would generally not constitute the same activities for the purposes of paragraph 3. Thus, for instance, paragraph 3 would not require that the taxation on a permanent establishment whose activities include borrowing and lending of money, but which is not registered as a bank, be not less favorably levied than that of domestic banks, since the permanent establishment does not carry on the same activity. So this is just an example to say that the two enterprises must be engaged in the same activities. Another example would be that of activities carried on by a state or its public bodies, which, since they are controlled by the state, could not be considered for the purposes of paragraph 3 to be similar to activities that an enterprise of the other state performs through a permanent establishment. So therefore, these are instances where the two enterprises were found not to be engaged in the same activities in order to invoke the benefit of paragraph 3 of Article 24. Now here, for instance, this judgment from the special bench of the tribunal in Rajesh Sureshbhai Gajwani was dealing with a situation where the permanent establishment of the non-resident was carrying on export activities from India. And the question was whether the benefit of deduction under section 80HC, which is available on export profits, could be allowed to the PE, because the benefit is otherwise available to a resident engaged in the business of export. So the special bench ruled in favor of the non-resident and held that the non-resident could not be discriminated vis-a-vis the resident when it was carrying on the same export activities from India. Now, another instance is that on deduction of head office expenses. Now, as you know, in terms of Article 7.3, when you determine the profits of a PE, you determine the profits as per domestic laws. And we have a restriction in section 44C that head office expenses are allowed up to the limit specified in that particular section. Now, a question arises that so far as a resident is concerned, there is no restriction on deduction of head office expenses. But whether that should apply to a PE and whether that can be said to be discriminatory, the Mumbai bench of the tribunal ruled in favor that this restriction constitutes discrimination, and therefore there cannot be an artificial ceiling on deductibility of head office expenses to the PE. But the applicability of a higher rate of tax on a PE of a foreign company was upheld by the judgments that are quoted on the slide as not being discriminatory and therefore not falling foul of paragraph 3 of Article 24. So here this is the explanation that I was referring to, and there are questions on this which we will deal with as we come along. There is the treaty that India has recently signed, which specifies that in terms of Article 7.3, if there is the restriction on deductibility of head office expenses, that would not constitute a case of discrimination in terms of Article 24.3. So this particular treaty enacts that provision. So these treaties provide that the provisions of Article 24.3 shall not be construed as being in conflict with provisions of Article 7.3. So where the treaty specifically provides, then clearly that will not amount to a case of discrimination. Now I come to deduction discrimination, which is paragraph 4 of Article 24. And this reads, except where provisions of paragraph 1 of Article 9, paragraph 6 of Article 11, or paragraph 4 of Article 12 apply, and all of these apply in the context of related party transactions, business profits, interest, and dividends in the context of related parties, apply interest, royalties, and other disbursements paid by an enterprise of a contracting state to a resident of the other contracting state shall, for the purpose of determining the taxable profits of such enterprise, be deductible under the same conditions as if they had been paid to a resident of the first mentioned state. So you are equating a transaction between a resident taxpayer and payment made to a non-resident for interest, royalties, and other disbursements, and payments made by the resident to another resident. So for the deductibility, there cannot be separate conditions so far as the payment to the non-resident and to a resident are concerned. So it is in this context that the courts have interpreted the provisions of paragraph 4 of Article 24, and so this is just illustrating this particular paragraph, that you have the Indian subsidiary and you have an Indian company. There is a payment made of interest by the Indian subsidiary to the Indian company and also made to the UK parent. Now, in case the payment of interest is at arm's length, the question that arises is, can there be different conditions regarding deductibility of such payment by imposing conditions under the Indian statute which are only applicable to a non-resident and not for the payment made to the resident. So in this context, if you see, we have the Delhi High Court judgment in the case of Herbalife, which dealt with this question of deduction non-discrimination, and it ruled that in the context of payments made to a non-resident, we have section 40AI in the Income Tax Act, which provides that tax has to be deducted on payments made to a non-resident. If tax has not been withheld, then the payment is disallowable in the hands of the resident. At that relevant point of time, you did not have the corresponding provision of section 40A, which imposed similar condition for deductibility of payments made to a resident. So in that context, the Delhi High Court ruled that this would be a case of discrimination, of deduction discrimination in terms of paragraph 4 of Article 24, and therefore the disallowance made in the hands of the Indian resident for payment made to the non-resident under section 40I could not be sustained. So this is the view that the Delhi High Court took in the case of Herbalife. Now this was also argued in another matter, that on payments made by the PE, let us say for purchase of goods to the non-resident, the payment is not liable to tax in India, and the question of deductibility of tax should not arise, because in terms of section 194C or any other provision of the Indian Income Tax Act, there is no requirement of deducting tax on payment of sale consideration for purchase of goods. So the Delhi High Court in the case of Mitsubishi has referred this matter to a larger bench, and the larger bench is yet to decide this particular issue as to whether, with respect to payment for purchase of goods, whether the non-discrimination article would apply, considering that there is no provision in the Income Tax Act obliging an Indian resident to deduct tax while making payment to a resident seller of the goods. Now coming to this Article 24.4, this will need to be tested in the context of 94B, and I see there is also a question on it, that whether provisions of 94B would fall foul in terms of the non-discrimination article, because 94B provides that payment of interest by an Indian resident to an associated enterprise would be deductible only under certain conditions. Now there is no bar on the deductibility of the entire interest paid by the resident to another resident lender, even if that resident lender be an associated enterprise or a related party in terms of Section 40A2. So therefore, can one argue that in Section 94B does not pass the muster of deduction non-discrimination? This is something that will be tested in the days to come in the courts, but clearly this is one example which, according to me, is a case of discrimination. Then let me illustrate this point again on, although not to do with 24(4), but the question of transfer pricing. Now, a special bench of the tribunal has recently ruled that just because transfer pricing is applicable to a non-resident does not imply that the non-resident is being discriminated, or that the transfer pricing provisions should not apply in the case of a non-resident. Although in the context of determination of business profits, when you go to Article 7, you have Article 9 of the treaty which talks of associated enterprises and imposes the condition that you have to compute profits as if the two entities are operating at arm's length, as if it was a case of a comparable uncontrolled transaction between two independent unrelated entities. But what I had argued in a particular matter was, if there is a sale of shares between two non-residents, sale of shares of an Indian company between two non-residents who happen to be associated enterprises, and at that time we did not have Section 50CA in the statute, which allows the Indian revenue to impute a notional consideration, a sale consideration for sale of shares between two Indian parties. Now, in the absence of such a provision, when a resident sells a share to another resident, you would determine the income in terms of Section 48 by taking the actual sale consideration, or even if a resident is to sell to an unrelated non-resident. But here, between two related parties who are non-residents, because the income has nexus with India, being shares of an Indian company, why should the non-resident be subjected to transfer pricing and an addition be made for consideration not received by the seller non-resident? The tribunal has decided the matter against me, but the order is bereft of any reasoning, and therefore at the moment the tribunal's order holds the view against the assessee so far as this aspect is concerned. But I am sure this will be tested in several other matters in the times to come. Article 24(5) deals with ownership and non-discrimination, and it provides that enterprises of a contracting state, the capital of which is wholly or partly owned or controlled directly or indirectly by one or more residents of the other contracting state, shall not be subjected in the first mentioned state to any taxation or any requirement connected therewith, which is other or more burdensome than taxation and connected requirements to which other similar enterprises of that first mentioned state are or may be subjected. So this is basically seeking to prevent discrimination based on ownership. So if you have an Indian company which is owned by a non-resident, merely because it is foreign owned, that cannot be a basis to discriminate against the foreign owned Indian entity, Indian incorporated company. And this seeks to prevent that kind of discrimination. So again, you are referring to similar circumstances or similar enterprises of the first mentioned state. So basically you need to draw this parallel between the activities carried on by the entity which you are claiming is subjected to discrimination and the entity against which you seek to make that comparison. So therefore this is important to understand this information. So merely because, again, a foreign company or a foreign owned company is subjected to stringent disclosure requirements vis-a-vis its Indian tax obligations, again cannot, in my view, be treated as a case of a discrimination just because they have the obligation to disclose further information with respect to its overseas operations. Then lastly, this is the residuary paragraph, the general paragraph, which reads, this is Article 24(6), the provision of this article shall, notwithstanding provision of Article 2, apply to taxes of every kind and description. So this now the paragraph is wide to say taxes of every kind and description, and there have been judgments which say that this would include even custom duty. Although the scope of the double tax treaty is to prevent double taxation or double income taxation, but some courts have interpreted this to mean that this would also include the incidence of indirect taxes. So therefore, India has in some countries, some treaties clarified that the term taxation means taxes which are subject of this agreement. And if you see Article 2, that will define the taxes that are the subject matter of the tax treaty between India and the respective country. So friends, this in the short time allotted to me is a snapshot of Article 24 and the various nuances attached to non-discrimination. So this is tested not very frequently in the courts, and I think over time one will see increasingly this being debated in different forums. Thank you.
Yeah. Thank you, Mr. Vohra. And I was just going through some of the questions which have come up on the chat box, and I know there is one topic which you have actually dealt with, and probably I'll ask a question on that and also on one more topic.
Yeah.
Which is one is on thin capitalization. I know your paper does deal with it to see whether thin capitalization, whether it should be treated as a case of non-discrimination. And I'll give one more example, the whole equalization levy. Yeah. Because especially when we start looking at 24(6), you start reading that with non-deductibility on equalization levy if there is a failure to withhold, or even now the more expanded provision on equalization levy. Are these all areas that you think that you're going to see more and more litigation around, purely when on one hand we have India which is trying to expand the source, the base as much as possible? Do you see the kind of push and pull coming in on these areas?
I think very interesting question, Rajesh. This is not just limited to Article 24(6). This whole issue of equalization levy has sparked off a huge debate. And the question is whether this is a tax on income, whether this is an indirect tax, what is the nature of this tax? This is levied through the Finance Act, and one is not sure whether it is part of the Income Tax Act or it is part of, let us say, the Excise Act or the GST for that matter. So first the question is, A, whether this is constitutionally valid. B, as you said, in terms of Article 24(6), if for the present we restrict ourselves to 24(6), whether it is covered in taxes of every kind. And I would take it that since this has come through the Finance Act, it may be possible to contend that it should cover this equalization levy, and therefore the equalization levy should be within the ambit and scope of this paragraph 6 of Article 24. But these are debatable questions. One doesn't have ready answers at the moment. But yes, you are right. This will stir up a hornet's nest.
Thank you, Mr. Vohra. And I think while I know that on rate of tax there's been a lot of debate, but purely, and our courts have always said that you can have a discrimination basis rate of tax, but purely from the perspective that where, as you pointed out, there are some treaties where it's actually called out, and in other treaties it's not called out. Would you then say that merely because there was an amendment to the Income Tax Act as a clarification under explanation 1 does not necessarily mean that I still need to look at the treaty, and there are treaties where in fact in most treaties there is no clear answer which is given saying that rate of tax cannot be a ground for discrimination. Any thoughts on that?
I think you have touched a larger point, that whether an amendment unilaterally made to a domestic legislation should seek to override the treaty provisions. Now that has been answered by the courts in the case of Sanofi and several others, and this matter of course is again right before the Supreme Court, that whether there can be a unilateral treaty override by making an amendment in your domestic legislation. But leave that apart. I think what is important is that you seek to make a comparison between enterprises placed in similar circumstances. Now, if you look at what the courts have held in the context of differential rate of tax on a foreign bank versus a domestic bank, is that the domestic bank has several regulations that it has to comply. It has some government norms or government directives that must be followed, which are not applicable to a non-resident bank, which is not considered as a scheduled bank in terms of the RBI Act and so on. So they have justified the differential rate of tax on that basis, that they are not similar or they are not operating in similar or same circumstances.
And Dhruv, I know you did want to have a quick thought before we move into Mr. Bhutani. Why don't I just get you in?
Sure. Thank you very much. Actually, on the rate of tax, it's very interesting. If I could just look at the language and also look at the commentary of the OECD, it talks about a less favorable levy. It does not talk about rate of tax. It does not talk about deductions at all. And if one looks at the commentary, it's the second sentence at paragraph 34. It says, in the negative form, in which the provision is concerned has been framed, it is the result alone which counts, it being permissible to adapt the mode of taxation to the particular circumstances in which the taxation is levied. So you have two aspects to taxation. One is the tax base and the other is the tax rate. Now, there are quite often that residents and non-residents are allowed different tax bases. Different deductions may be allowed, accelerated depreciation, etc. Presumptive profitability and things of that sort. So in the end, if it's the final amount of tax that has to be paid is what matters, it's a bit surprising to me that this point has not been taken up by any of the courts. Wouldn't you think it would be a reasonable argument to make that in the end, all that Article 24(3) prevents is that the final number of tax based on the activities should be put at par with that of a resident? Whether you tax it at the same rate, whether you grant the same deductions, that does not matter at all. And once we do take this line of argument, then what is the unilateral amendment in Article 90, paragraph 2, the explanation, wouldn't matter at all. Because you say you apply whatever rate, but it's the final outcome that matters. That has to be put at parity.
No, you are, Dhruv, you are right. But if I was just thinking aloud that if you look at a taxation of a PE of a foreign company and a domestic enterprise, I think other than in terms of deductibility of expenses for a moment, I don't think there is any difference other than maybe head office expenditure. If you look at income, you follow the same yardstick of accrual of income or the cash system of accounting. So there is really no difference in the base, except, as I pointed out, the head office expenditure. And maybe, in certain situations where, for instance, if you don't pay tax on the salaries of your foreign personnel on the basis that they are not present or they are not connected to the PE, that's a different situation. But the tax base remains the same. Now, the rate of tax, I think if you go back historically, we have always distinguished between a resident and a non-resident. Even a non-treaty partner, where you subject a non-resident to a different rate of tax. And this has been there historically. So I am not sure whether this distinction between a resident and a non-resident, which is ingrained in our income tax statute for time immemorial, would amount to a case of discrimination. Because the PE is not a legal entity. It is treated as an assessable entity. Ultimately, you assess the foreign company as a non-resident.
Absolutely.
So it is in that context, I think, therefore, the differential rate of tax may be justified on those grounds.
Okay. Thank you very much.
Yeah.
Thanks, Dhruv. Thanks, Mr. Vohra. And I think, let's move into our second topic, which is on the principal purpose test, for which we will have Mr. Bhutani coming in. The session will be extended till around 8:25 to 8:30 p.m., which is for another half an hour, just considering or managing time. But I'm not going to go on too much in terms of introducing Mukesh. Again, very old hand in Indian context. Everybody knows Mr. Bhutani. So Mukesh, over to you.
Thanks, Rajesh. Good morning, good afternoon, everyone. Thanks, Nishith Desai, for giving this opportunity. I'm sorry, my email connectivity, internet failed me, typical Murphy's Law. So I'll need some help because I understand how to share the presentation when I'm on my laptop, but I'm unable to make out how to share the presentation when I'm on my iPad. So if you can help me, I'll be grateful. I'm just trying to see if I can see the share button, which I can't. Yes, I can see it actually now. So
yeah, we can all see you and you look good and hear you well as well.
thank you, Nishith bhai. Yes, absolutely. Yeah, you can move the slide. So what I intend doing is in the next 15-20 minutes, give you a little brief overview on how the evolution of Article 7, because the whole idea is to deconstruct Article 7 of the MLI, how it evolved. I was looking at the presentation, which was made by Dinesh Bhai, and he's brought out, the distinction between the Indian GAR and the PPT. So I'm not going to repeat any of that. I will also just take you through the basic clauses under the MLI insofar as Article 7 is concerned. Just try and distinguish between what I consider as subjective and objective elements of the PPT. Obviously, the subjective elements are the ones that have raised maximum concerns, and in my view also will become a subject matter of controversy. There are some other important questions that are coming up, whether the subjective elements in the PPT, if it is applied over and above the GAR provision, how it will be applied in the Indian context. And these questions are also coming up from the constitutional law perspective, because many of them are pretty vague concepts. And then finally, we will look at the friction between the PPT and the domestic GAR. I will not repeat what was stated in the earlier presentation by Dinesh Bhai, but I'll just point out some of the important functions. Go ahead. So let's try and look at the background. So Action 6, gave some very important findings. It basically identified that taxpayers which are engaged in treaty shopping, without defining what is treaty shopping, it used the word treaty shopping and other forms of abuse strategies. They tend to undermine the sovereignty of nations, and more importantly, the existing bilateral agreements do not have adequate anti-abuse provisions to prevent the treaty abuse. I'll just try and draw a distinction also with the 2014 Model Convention, and hence what Action 6 recommended was that we should have treaty abuse for a variety of reasons. And amongst various reasons, they identified three important reasons. Number one, when treaties get negotiated between the parties and the agreements are economically extended to residents of a third jurisdiction, the principle of reciprocity is therefore breached, and the balance of concessions that the parties make is also altered. First objective. Second, income escapes taxation altogether or are subjected to inadequate taxation. Third, it reduces incentives to enter into double tax treaties. So these were the three important treaty practices that were identified, and for these reasons, Action Point 6 was born. Broadly, the recommendations identified that there are two forms of treaty shopping. One is a rule shopping, where attempts are made by the taxpayer to circumvent limitation that's provided by the treaty. And this is the easier part. The second one, which is the most complex part, is that there is treaty shopping by way of attempts by the taxpayer to circumvent domestic tax law using treaty benefits. Now, this is a tricky one, particularly in the Indian context, given how our domestic law is worded, because the domestic law clearly provides that whichever treatment is more beneficial to the taxpayer can be taken. Let's move ahead. Now, how was Article 7 of the MLI born? We looked at what were the BEPS recommendations. What I read out in the earlier slide arose from Article 10.7 of the BEPS Action 6 recommendation. This article is mirrored in Article 7 of the MLI, which is what we are going to deconstruct today. But before we get to that, let's look at what the 2014 OECD Model Convention said. Article 1 said that a benefit will not be available where main purpose of entering into agreement was to secure more favorable tax position. This was kind of an inbuilt anti-abuse provisions enshrined in Article 1 itself. Obviously, the Action Point 6 felt that this is not sufficient for all the reasons I stated in the earlier slides, and then it came out with a set of recommendations. Article 7, to give effect to BEPS Action 6 recommendation, essentially mirrored what Article 10.7 of the final BEPS recommendation on Action 6 suggested. And then in 2017, when the OECD Model Convention came, this was November 2017, essentially Article 29.9 of the 2000 OECD Model Convention mirrored Article 7 of the MLI. So this slide is essentially just to be able to give you how the PPT test has arisen and the distance that it has traveled. Now, let's look at the preamble before we deconstruct Article 7. Let's look at the preamble of the MLI. Article 6 deals with the preamble. It says the covered tax agreement will be modified to include, and the court is intending to eliminate double taxation. Now, this is the intention. So, because you cannot deconstruct Article 7 without reading the preamble to the MLI, which is Article 6. And many interpretative issues that are coming up on Article 7, perhaps the answers to some of them lie when you read the preamble to the MLI. Intending to eliminate double taxation with respect to the taxes covered by this agreement without creating opportunities for non-taxation or reduced taxation. There is similarity of wordings that have been used even in Action Point 6. Through tax evasion or avoidance, including through treaty shopping arrangements aimed at obtaining reliefs provided in this agreement for the indirect benefits of residents of the third jurisdiction. Now, what has been stated in the bracket insofar as the preamble in Article 6 is concerned is the value add that has occurred as a result of the BEPS Action 6 recommendation and also the one that has got incorporated in the OECD 2017 Model Convention. Now, what are the differences? The preamble recognizes that an added objective besides eliminating double taxation and fiscal evasion, and that added objective is not to create opportunities for non-taxation or reduced taxation, either that is occurring through tax evasion or avoidance, which was there in the earlier model, or treaty shopping arrangement. And the word treaty shopping has not been defined either in Action Point 6 or in the MLI, or for that matter in the 2017 Model Convention as well. And hence the purpose and the context of the treaty should reflect the preamble. So Article 7, which is what we are going to deconstruct, essentially contains the principal purpose test in consonance with the preamble, which is in Article 6. Now, let's look at first, what are the differences between the 2014 Model Convention of Article 1 and 2017 Model Convention enshrined in Article 29.9, which mirrors Article 7. The 2014 was relatively simpler, straightforward, and also easy to interpret. No treaty benefit, where main purpose of entering into an arrangement was to secure a more favorable tax position. The 2014 Model Convention on more favorable tax position also came up for debate in many countries, but it was far less debated than what 2017 Model Convention will be debated. The equivalent of that is no treaty benefit if obtaining such benefit is one of the principal purposes of any arrangement. The second important, obtaining more favorable treatment would be contrary to the object and purpose of the relevant provisions. This was an exception that was clearly carved out in the 2014 Convention. There is a similar exception that has been carved out even in the 2017 Convention. It says unless it established that granting that benefit would be in accordance with the object and purpose of the relevant provisions. Now, you may find similarity in the exception clauses of 2014 and 2000 Convention. However, when you look at the burden of proof, it's different under both scenarios. Finally, the tax authorities under the 2014 Convention have to come to a clear evidence that treaties are being misused. That's not necessarily the case in 2017 Convention and Article 7. it has to, what they call it as, draw a reasonable conclusion. And we will try and look at it, what actually this means by saying the tax authority is drawing a reasonable conclusion, particularly if it has got to do with the arrangement. Before we get over there, let's try and look at some of the terms, go ahead, used in various parts of the MLI. And I'm not going to, and I'm just trying to use these terms only in the context of Article 7, which is the subject matter of discussion today. One is an operative clause. An operative clause means this will apply irrespective. Second is a compatibility clause. Before we get to the compatibility clause, there's a reservation clause. The reservation clause is more by opting out. So if you opt out, what happens? First, you express a reservation and you opt out. It is for each parties that are signatories to the MLI to express a reservation on any of the operative clauses. Now, when you express a reservation, two outcomes are possible. Either you have a reservation which can be explained by way of alternate provisions, or you have a reservation that can be explained through by invoking what we call it as a compatibility clause. If you invoke the compatibility clause, you can have an asymmetry situation or a symmetry situation. And then finally, the notification clause is very relevant. So these four terms that have been used, they are very important from the point of view of making sure that you read the MLI with the intent with which it has been stated. Next, please. There are other terms that have been used also in the MLI document as a whole. I'm not going to focus on all of the terms except for the third important term, which is the clause that deals with applies or modifies. This is particularly relevant because Article 7.5, which deals with prevention of treaty abuse, which is the subject matter of our debate today, is important because the effect of this clause means that the provision changes the application of the existing provisions without replacing it. And this is very tricky if you go into the analysis of some of the treaties that we are going to look into today. Go ahead. This is a very crowded slide, and I have no intention to spend a whole lot of time on the slide, but the purpose of this slide is to be able to put in perspective the two earlier slides. One, various clauses in the MLI. Two, in what shape and in what form opt-in and opt-out provisions work. So the Article 7.1, which is a default option, it essentially says tax benefit not granted if one of the principal purpose of the transaction or arrangement is to obtain a benefit. It's like a charging provision. The most other important part of the operative clause is Article 7.4, wherein countries have a right to opt in for what is called as a discretionary relief. It's optional, or there are alternatives that have been provided. This is particularly important for India because India has not notified this particular clause, and this will create a degree of incongruousness with some of the treaties that India has. Article 7.6, which is a very important operative clause, is an opt-in provision for simplified LOB test, and India has adopted it. It's a different story altogether that if you analyze the treaty, India found itself in minority, being amongst one of the 12 countries that had adopted PPT plus a simplified LOB test. We can move ahead because my objective was to be able to explain the operative clause, but if you actually get into the treaty, there are other important clauses as well which come into play. Now, I mentioned about the compatibility clause earlier, and this is just an illustration of a symmetrical compatibility clause versus an asymmetrical compatibility clause. Very simple. Both India and UK have signed the MLI. India has adopted PPT and SLOB under Article 7.4. UK has adopted only the PPT. The question is, how will it apply now in the context of the treaty? The answer is very simple. Treaties shall apply only the PPT clause. The SLOB will not be applicable insofar as India-UK is concerned. Now, it becomes a little tricky if you look into the asymmetrical part of the compatibility clause. Let's take a case of India-Greece treaty. We all know India has opted under Article 7.4, which means the PPT and the SLOB will apply. Now, Greece has applied for a PPT under Article 7.7, which is the compatibility clause. Now, the implications of this is that Greece will invoke the PPT clause if tax benefit is denied to an Indian resident, and India will invoke the PPT and the SLOB for denying tax benefit to a Greek resident. Now, it's one thing to say that it is not incongruous because the MLI as a document has dealt with this asymmetrical positions, but these asymmetrical positions can arise if you look at some of the treaties. Go ahead. Now comes the objective and the subjective elements of the PPT. Now, it's not defined anywhere in the MLI document that what constitutes an arrangement or a tax benefit or the revenue concluding that it's reasonable to conclude are objective tests and others are subjective tests. These are just views that are expressed by authors. Personally, I feel that reasonableness to conclude is not an objective test. This is clearly a subjective test. But when I was putting this slide together and when we were writing the essay, we felt we rather go by the views expressed by international experts rather than trying to thrust our views. But personally, I felt reasonableness to conclude is a subjective test. Now let's try and see how these tests will be interpreted, because some of the terms are indeed defined in our domestic law. Go ahead, please. Now let's look at the objective elements first, meaning of what is an arrangement. The OECD commentary clearly highlights an arrangement. We all know that arrangement has a much wider term. For example, India, in many cases, in the context of transfer pricing law, has said arrangement includes anything which is acting in concert by two parties, even if there is no agreement between the two. The trick is the latter part of the definition of the term arrangement. Creation, assignment, acquisition or transfer of income itself or of the property, right in respect of which the income accrues, arrangements concerning the establishment, acquisition or maintenance of person who derives the income, determination of that person as a resident of one of the contracting state. I was just picking on some of the terms. Many of the terms used in the OECD commentary have been used actually in the income tax statute. Whether they have been used in the context of deeming fiction under 911 or retrospective law or definition of the term transfers in the capital gain chapter, many of these terms are defined. And the reason these definitions are important is because when you apply the objective test of the PPT, you're essentially going to rely on your domestic law and the jurisprudence that's available in India to interpret these terms. Interestingly, the Income Tax Act also defines what's an arrangement in the context of an impermissible arrangement. And it's important because it talks about a step transaction as well. And though it is in the context of the GAR law, there is a definition of the term arrangement in the GAR chapter as well. Go ahead, please. Let's look at the other important element of the term tax benefit, which is again featuring in the chapter on the GAR law as well as in the OECD commentary. Now, interestingly, in the OECD commentary, double taxation is also considered as a benefit specifically. It includes limitations such as tax reduction, exemption, deferral or refund or taxation. Tax reduction. Now, when the GAR law was being formulated in India, it was specifically answered in the FAQ before the rules were announced that a taxpayer is well within its legitimate needs to claim benefits that are otherwise statutorily available under the law. There is no guidance insofar as the OECD commentary is concerned because it says limitations such as tax reduction as well. Non-discrimination and procedural rules. So these have been specifically excluded. So it was identified earlier in Action Point 6 itself that the non-discrimination clauses of the treaty and procedural rules insofar as the treaties are concerned, such as arbitration clause, which doesn't apply to you, will not constitute a tax benefit. However, we have most favored nation treatment in many of our treaties, and it is unclear that whether most favored nations treatment would be considered as a tax benefit. My personal view is it will not be considered, but I'm sure that it would be debated. The term tax benefit is also decided in the context of the GAR law, which you need to keep in mind. Please go ahead. What is the definition of reasonable to conclude? Now, I mentioned earlier that this is a very important aspect and, in my view, extremely subjective. Now, the OECD has not given any guidance. However, the commentary and the experts' view suggests that since this is a test that will be applied by the tax administration, because it is up to them to reasonably come to the conclusion that a tax benefit should be denied under the PPT, it is important for the tax administration to look into the question of facts. There should be proper investigation that should be undertaken in light of all the facts. The purpose of the arrangement should not be lightly assumed by the tax administration. More importantly, an arrangement itself cannot only be reasonably explained by a benefit that arises under the tax treaty, and it concluded that there is no conclusive proof of the intent, and each and every case has to be evaluated on the merits. Now, there are a lot of international jurisprudence that's available on this test of reasonableness, and that jurisprudence is also available in the context of India as well. Next, please. Now, let's look at the subjective elements, which is the meaning of the term, one of the principal purposes. I'm not going to repeat what has been stated earlier. We know that in the GAR law, it's the main purpose test, and in the PPT is one of the principal purpose tests. This becomes particularly relevant because certain sections of the administration in India have taken a view, and this is not a view that's coming in officially, which says that the principal purpose, even if a taxpayer crosses the bar insofar as the applicability of GAR is concerned, the principal purpose test will apply. As a matter of fact, some of the views are that the principal purpose test is a primary test. You will not enter into a situation of claiming a tax benefit under the treaty until and unless you satisfy the principal purpose test. Now, most of these views are not without basis, and hence several questions arise not just in the context of objective tests, but also subjective test. And how will it apply in the context of India? The reason this is important is because the onus will be on the tax authorities to produce this not beyond doubt, as it was in the 2014 convention, but it should be a reasonable purpose and not beyond doubt. And the concern is that a wide approach would target all forms of transaction that potentially might be, but which are not actually abusive. Finally, we deal with the exception clause. That the exception clause is clearly a carve-out. It basically protects the taxpayer from claiming the treaty benefit if it is in accordance with the object and purpose of the relevant provisions. Please mark my word, it's relevant provisions. Dhruv alluded upon it in the earlier presentation that it's the relevant provisions and not the entire treaty. The onus clearly lies on the taxpayer to prove this if it wants to fall within the exception clause. And the treaty objects and the objects of a particular provision can be very varied. It could be elimination of double taxation, promotion of exchange of goods and services, movement of capital. It could be fostering economic development, trade, investment, and many of this do appear as the object of the treaty with insofar as India is concerned. So now you need to go back and read the preamble to the MLI contained in Article 6, because that, in my view, is a very important aid for determining whether a taxpayer falls in the exception clause or not. Next, please. Now, this is India's position. I'm not going to labor on this slide. Suffice for me to mention that the point that I mentioned earlier in the context of Article 7.4, which is the SLOB test, this was India's provisional position at the time of signing the MLI document. And when all the information was available, India found itself in the company of a minority nations, which has been stated in the slide below. And hence the final position set the principal purpose test only as an interim measure plus the SLOB clause. However, India expressed its intention to adopt an LOB provision over and above or in replacement of the PPT. Obviously, this is possible only through bilateral negotiations, and there are some interesting trends coming out of the treaties that India signed alongside when the documents were being negotiated. One classic example is the India-China Treaty. Go ahead, please. I mean, to some extent, we have dealt with this slide, or it has been dealt with in the earlier presentations. The objective of this slide is to be able to say that the domestic guard provisions has an outcome, which is what the revenue authorities will do if they come to the conclusion that GAR has to be invoked for an impermissible transaction. For PPT, it's simply denying of the treaty benefit. The onus in a domestic GAR shifts to the revenue. To start with, it certainly creates a deeming fiction, and the primary onus on the taxpayer. In a PPT, our view is that the burden of proof is on the administration until and unless the taxpayer wants to fall in the exception category, in which case the onus of proof is on him to be able to prove. The other important element is that GAR has checks and balances in terms of how the revenue is going about to come to the conclusion that this is an impermissible agreement. A PPT does not have any checks and balances. It simply says that if the revenue comes to the conclusion that you fall fault of the preamble and Article 7.1, which is the operative part of the PPT, then the effect is simple denial of the treaty benefit. So to that extent, it is onerous, no doubt about it. Next, please. This is just a simple analysis of how it will apply. I'm not going to talk about Mauritius because Mauritius has not notified India, but China is a very good example. India signed its protocol with China on June 15, 2019, when it had gone past the entire MLI signing process and almost close to India putting out its final position, which was on June 25, 2019. And by that point in time, the protocol to the India-China Treaty was signed. Now, the revised preamble to the India-China Treaty essentially picks out Article 6.3 of the preamble to the MLI. So the preamble to the MLI is now put in the treaty with China. Go ahead, please. This is just a conclusion slide, and this slide is more a question. This question is not with a view to make the applicability of MLI redundant, but I think it's equally important to know that India has some very interesting trends in treaty when it comes to application of treaty abuse provisions. So I just tried to basket it in 4 categories by saying that we have treaties with nations where there are general anti-abuse provisions. We have treaties where we have specific anti-abuse provisions, and the protocol to Singapore and Mauritius specifically deal with it. Then we have treaties which specify use of domestic guard to override the treaty. These are some of the new treaties: Hong Kong Treaty, Luxembourg Treaty, and the protocol to India-Spain Treaty. And then we have treaties which will be impacted, which at this point in time don't see an impact because these are not covered tax agreement. And when I use the word NCAT, I mean non-MLI covered tax agreement. And then these treaties will come into force as soon as they are notified. So these are the treaties to watch out for as well. Next, please. So essentially, there's a lot of stuff that we have dealt with in our essay. How would this be interpreted? Where would the Vienna Convention on Tax Treaty, insofar as good faith principle is covered under Article 31(1), will be looked at? And we've looked at some of the ICJ decisions on common intention of the parties to enter into a treaty, and look at the definitional aspect and the contemporaneous nature of the treaty negotiation. So if you get an opportunity, do read the essay, which is far more detailed than what we will be able to cover in this brief time. Thank you.
Thanks, Mukesh, for that. And while you were speaking, I was just going through. I think there was a lot of activity on the Q&A box, and I'll just try and take a couple which were actually quite interesting. I think there's one question which is there around the Irish rental arrangements on aircraft, because that's a very common arrangement that you actually tend to see, where you have an Irish company which is there, which leases aircrafts on operating lease to people across the board. And again, that treaty is one of the few treaties which provide for aircraft rentals, very specifically provided for in the treaty. I think in that context, I think one of the questions which comes in is that where you have treaties which have negotiated these special clauses which are there, how do you then start looking at PPT? Would you sort of be a bit more, what you would call prudent in terms of trying to override treaty benefits, where it seems that there are specific negotiations which have happened on those provisions? I think that's one interesting topic. Would like great to hear your thoughts on.
So, Rajesh, thanks for the question. And in a way, I'm glad that I did not labor the point on Vienna Convention of Tax Treaties in detail, because perhaps the answer lies in how Article 31(1), 31(2), and 31(4) of the Vienna Convention would be interpreted. So we all are familiar with 31(1), which is the good faith principle of the Vienna Tax Convention, but we don't tend to look at Article 31(2), which is the context, and also Article 31(4) as well of the Vienna Convention. So let me just try and put this in perspective. 31(1), which is a good faith principle, simply says that the terms of a treaty will have to be given their ordinary meaning unless the parties have given a special meaning. Now, people may wonder, okay, let me step back a little bit. When the MLI as a document was getting evolved, there was a lot of debate, and the MLI working papers also have wide references to the Vienna Convention on Law of Treaties, because I think the concern was whether those principles will in any manner get diluted because of the preamble or because of Article 7(1). So Article 31(1), which is a good faith principle, says that unless the parties have given a special meaning. Now, will a nation's right to sign the to come and together and sign the MLI document to notify each country as under the covered tax agreement fall in the exception category of Article 31(1)? My point is that it is debatable. It could not. But then let's look ahead of Article 31(1) to Article 31(2), and perhaps the answer to the Irish leasing structure lies in 31.2. It says that the context that should be taken into account while interpreting a treaty shall comprise first the treaty itself with its preambles, annexures, and protocols. Now, is this a protocol? It is not. People may want to argue, well, this is not a protocol, but since the MLI now has to be read alongside the treaty, it has as much status of a treaty. One of the experts and interpreters on international treaty law said that when you look at the context of a treaty in the structure of a sentence, the paragraph and the article as a whole has to be read. The explanatory statement to the MLI can be read as a context of the MLI, which stipulates the object and purpose of the MLI. They being to implement the tax treaty related measures. And the commentary developed during the course of BEPS Action 6 is also of particular importance to determine the purpose of the relevant provisions. I'm not going to be able to come to a conclusion whether Irish structures would be questioned or not questioned. But I came across a very interesting judgment between the state of Costa Rica and Nicaragua, and this is in the context of law of seas. The International Court of Justice said that the common intention of the parties to the treaties must be by definition contemporaneous with the treaty's conclusion, as the parties cannot anticipate at the conclusion any future developments. If I read the ratio of the ICJ in this case, it doesn't seem to me that the PPT now is going to go and disturb the Irish structures that have already been put in place based on the reading of the treaty, which had existed at that point in time. However, it could come under question if there are new leases that get signed post the PPT coming into implementation. So I'll just rest my case there only.
Thanks, Mukesh. And I think, and just for everyone's benefit, I am aware that the cases relating to Irish lease rentals are currently, there is a matter that's pending in the Delhi High Court on that issue, though that's more on 147, but that issue is actually there. I think one more interesting question which actually comes up is that, will double non-taxation in every case fail PPT? Again, I would always tend to think that that should not be the case, but happy to hear you again on that.
I don't think that the double non-taxation will, in my view, change the situation. I think the challenge that we have with the application of PPT test is the test of reasonableness. Many concerns have been raised, including the fact that it has significantly lowered the burden of proof insofar as the tax authorities are concerned, to the extent that there is a risk that treaty benefits may potentially be undermined by excessive administrative discretion. And hence, there is greater need to be able to balance the aim of combating tax abuse and the aim of providing easy access to tax treaty benefit. Because if PPT definition and the intent with it has been stated has to be interpreted in its truest form, then we should kiss goodbye to double tax treaties. This is very different than Article 1 of the 2014 Model Convention, because it certainly creates a friction. What happens to a taxpayer who has negotiated the treaty under the earlier Model Convention? Does it mean that now you can supplant the 2017 Model Convention, particularly Article 29.9? My answer is no. Specifically in the Indian context, we have to bear in mind that we have the Constitution that specifically lays down the principles for taxation. So the Constitution doesn't prohibit states to legislate a law which have extraterritorial applicability, but anything that is broad, vague, or arbitrary in nature, which I think PPT is, at least when it comes to its application, then it invites a question on the constitutionality. I'm very tempted to actually quote a very important ratio of a Supreme Court decision This is the Chief Settlement Commissioner versus Om Prakash. And the ratio is squarely applied, and I think the revenue will have to be very mindful when they apply the PPT test and the manner in which they apply. It says that in our constitution system, the central and most characteristic feature is the concept of rule of law, which means that it is the authority of the courts to test all administrative action by standard of legality. In principle, it is imperative that the tax authorities do not act in an arbitrary and whimsical manner. We know that, but it further goes to say any application on part of the authority must be sound, and all laws must be certain and predictable in application of this universal principle. The PPT, in my view, fails to adhere to the constitutional benchmarks of legality by putting the threshold under reasonable case for the tax authorities to conclude. And I think the only solution, in my view, is the domestic law has to provide administrative guidance, and it becomes essential because that will also mean that there are safeguards as well. Interestingly, the ratio of this case in the Chief Settlement Commissioner was quoted by Justice Kapadia in Vodafone case as well.
Thanks, Mukesh. I think the point that you made in terms of having procedures set out or internal guidance that is set out, that actually I think is actually a very important element, especially in terms of ensuring that we don't end up in a situation where you just increase the quantum of litigation around the PPT. I think while there are a few other questions, I know we are running short of time. I do see one question from Clive Baxter on SLOB versus long form LOB. My understanding is that India is looking at SLOB rather than the long form LOB. I don't think we have too many treaties or intend to actually negotiate a long form LOB. But with that, why don't I give it to, unless anyone has a thought around it, Mukesh or Dhruv. But otherwise, let me just give it to Nishith Bhai. Nishith Bhai, a few words from you, because I know we've already gone past the scheduled time, but well, it was an interesting session.
So Dhruv, you have nothing to say more, right? Okay, great. So thank you very much. I think, first of all, apologies for extending the time, but I thought and we thought that when we have stalwarts like Ajay Bhai and Mukesh Bhai, if I may call them Bhai, and for preparing so much and giving exposition so enthusiastically, we thought that it would be useful for all the participants, which are there in hundreds, and it will be very useful. All the recordings also would be available in about a week's time, But before that, let me thank everyone. I think this has been a fantastic discussion, I must say. The amount of hard work that goes into preparing and giving us the benefit of their experience is enormous, and therefore we did not feel it appropriate to cut short the presentation. And this is an educational series. It's just not something cut and paste kind of thing. So hope all of you will, bear in mind that we extended the time so that more people and younger people can also benefit from this educative series. So, this is what very important. But it is, I think, in the middle of all this chaos that is happening, there's so much subjectivity that is increasing. It is how do taxpayers and how do tax administrators even drive this whole economics of the international tax system. And that remains a big question we'll be discussing in the later part of our sessions. But right now it's time for you all to go and have a good dinner, I think. And I'm very, very thankful to you all for joining in so many numbers. Ajay bhai, thank you so much once again. Mukesh, thank you. Dhruv, thank you for your academic experience. And of course, Rajesh, you're always superb. I think it's wonderful to be interacting with you and great moderation. So with those words, I would like to close and thank you so much.
Thank you.